Thank you very much. We're now in the period where we ask questions of 5 minutes of each, and I will start with my 5-minute period. And first, I want you to reiterate, Professor Barco, the suggestions you had, because the reality is we can do oversight, and that's part of what this hearing is about, is oversight. But we can't stop or change the president's pardon power, except unless he tries to pardon himself, and that would go to court. What were your suggestions of legislation that could serve the same purposes?
Thank you for the opportunity to talk about them further. So I think so commutations reduce sentences that are excessive. That's the presidential power. So you could create other mechanisms that do the same thing, just not with the president. So we used to have parole in our system, and that was the main mechanism by which people got sentencing reductions. And if you look at the charts on when clemency starts to fall initially, it's when we have the advent of parole. So bringing some form of parole back, or a second look by a judge that allows it.
When was parole eliminated, in fact?
1984's legislation eliminated it. So anyone sentenced after November 1st, 1987 in the federal system cannot get parole.
Would the chairman yield for a moment?
Yes.
When you're referring to the parole elimination, you're referring to the institution of determinate sentencing, right?
Correct. It was part of the Sentencing Reform Act's package of eliminating parole and creating a sentencing commission. And people testified before Congress at that time saying, now that you've eliminated parole, it's going to put a lot of weight on clemency because we need to have an avenue for commutations. And that turned out to be particularly true because there were so many new mandatory minimums that came into play at the same time and then continued to come. So you have this lots of disproportionate sentences that were mandatory, that the judge had no power to do otherwise, and no back-end mechanism to correct them. So reinstituting some form of parole or a second look by a judge after a period of time could do the same thing as a commutation. It would just be giving it to a different actor in the system.
Do you know if that was discussed as part of the First Step Act?
I do know there's legislation that's being considered that others may know more about, the second look, which would allow for more back-end review. And I also know that the part of the First Step Act that allows people to earn credits as opposed to good time credits, participate in programming and be eligible for some reductions. You know, that's one other way that was supposed to expand the opportunity, and then also removing the requirement that DOJ had to file your petition for compassionate release. You know, that also opened up one other opportunity, but that's for people who have terminal illnesses and the like. For your kind of core group of folks who have excessively long sentences, I do think there need to be more opportunities for them, and I do think having a second look in the system would do it, and it would take some of the pressure off of the president.
Are there limits in the Compassionate Release Act as far as the number of years somebody would have had to have served?
No, that you can, a person can file their petition now directly with a judge. You know, can ask obviously to go through the Bureau of Prisons process, but does have the ability now to file with a judge and explain why they merit compassionate release. So, for example, if they have a terminal illness, if they're a caregiver and for a child, they're the only caregiver that's left that could take care of a family member because, you know, someone has passed away and the like. And I do know that people are filing petitions for extraordinary sentencing relief under that provision, arguing that they can do it in the case of...
Do you have any recommendations of changes in the compassionate release to make it more effective?
I do think it should be explicitly made available to people who are serving excessively long sentences and can, you know, demonstrate good behavior while they've been incarcerated. I think that's something that could be more explicitly made clear, because right now the folks who are trying to do that, you know, it will remain a question whether judges will accept those petitions.
So how do you do that? Are you suggesting putting out a public paper to the prisoners?
Well, I think that, so there could be legislative changes that make clear who's eligible and who Congress has in mind should be asking for sentencing relief. I do think, and I'll let some of the other advocates who worked more directly with people who are currently incarcerated, I do think word gets around about what opportunities are available in terms of opportunities, but not everybody has access to counsel to help them and the resources they need.
Ms. Roseberry, do you have any suggestions on things we can do legislatively to improve people's opportunities to get their freedom?
Yes, sir. Thank you for that question. I agree that the Second Chance Act, passing the Second Chance Act would be helpful to give folks a second look. We recommended that on the Colson Task Force. Of course, getting rid of mandatory minimums stops the process on the first end. Fully funding the First Step Act so that people can avail themselves of that. I think as of July of 2019, only about 3,000 people have been able to be released through that act. There needs to be programming so that people can come out. I would just also add that if we're concerned about safety, that we think about the fact that if prisons are overcrowded, then the folks who work in corrections are unsafe as well. That's one of the things that we found in the Coulson Task Force. And so there's a need for mercy for them as well to have folks come out.
Now recognize Mr. Johnson for 5 minutes.